Good evening, everyone. Thanks for joining us for the January 2023 monthly Labourlaw update. And as we begin the first quarter, we also have our IR Guru conversation as part of CEOTSG. We welcome Mr. Rakshit and also Mr. Ramesh Srinivasan for the IR Guru conversation, which would be followed once we get done with the monthly Labourlaw update. So without any further ado to time, we will commence on the monthly Labourlaw update for January 23. Not any amendments are coming, but there have been certain circulars. The ESA Act has been extended to a district in Orissa and to one more district in Punjab. The ESA Corporation has also issued a circular with regard to payment of contribution. When an employee is availing ESA benefits and the ESA pays the leave salary for the employee for the medical leave, they have also found that employers are making contribution for the same period. So that is a bit conflicting. So the employee gets a benefit of wages from the ESA Corporation and as well as from the employer. Employers are being requested to ensure that such kind of dual payment is not happening to the employees, and the contribution should not be paid for the days that the employees are not actually worked or where they have actually engaged the ESI leave. So to that extent, the Kollam region of ESA Corporation, Kerala, has issued a circular. So this, we thought it would be of help to everybody to remember to check whether you're doing a double payment to employees, whether employees are claiming leave salary from ESA Corporation at the same time also being paid salary by the employers. The Karnataka government has extended the Labour Welfare Fund payment till 31st of January 23. West Bengal government has announced a single window portal for the state tax on professions, trades and calling, professional tax basically. And from 1st January, it's in a single portal that they have introduced. The Puducherry government has renewal of various licenses, including Contract Labour Act, has been made through a web portal of the Labour Department of Puducherry, and it becomes mandatory filing from 16th January 2023 only through the online portal. Moving to the quiz segment for this month, the quiz question for this month is whether the provisions of the Occupational Safety, Health and Working Conditions Code 2020 is applicable only to factories, mines, plantations, audiovisual laborers, so workers. So you could put your answers in the chat box, and we would be giving out our answer at the end of the slides. In the Across the Globe segment this month, we get to see a judgment of the US court where the employees who were not aware of English or their law that they're entitled to what they're entitled to. A crew leader of one of the companies was taking the paychecks, encashing the paychecks, and was paying the employees much less than what they actually were paid by the company. But the government department, and it was from a public funded project. So when this came to the notice of the government, the company was held liable. The company had to pay a hefty penalty, but also the unpaid wages with interest. So similar enactments are available in our legislative scheme as well. For instance, under the Minimum Wages Act, if they find that there is any kind of shortfall, they could levy penalty up to 10 times. So transferring the wages through bank accounts directly would be a more safer approach going forward. Of course, most employers today do that, but it just to keep us reminded that we need to follow such kind of safe measures. This is a case where an employer of a software company had a software in the laptop used by the employee to track how many hours of work she does, and that software also had to distinguish between personal use and professional use. And the employee said that her termination, she was terminated for having logged in wrong details of the hours of work. and she challenged it. The court ultimately held in favor of the employer, saying that the software was capable of distinguishing between professional work and personal work. And if she had printed hard copies and worked on hard copies, she must have logged in the actual hours into the software as well, where there was a provision for that. So the court found the employer was right in termination of the employee. In the Knowledge Corner segment this month, we are looking at a theory called notional extension. Normally, the liability of an employer is considered only during the work hours and in the work premises, and it's not extended beyond that. But for purposes of certain enactments alone, it's given a more wider definition. So your work, coming to the work or leaving and going back to home from work, these and also certain other circumstances have been considered, and they are deemed to be part of the theory of notional extension. So that is what we are going to see this month in our Knowledge Corner. So if you look at under the Employees Compensation Act, that's one enactment where an injury suffered due to an accident arising out of and in course of employment it has been held to be work related in course of employment, and an employee is entitled to compensation. Secondly, similarly, under the ESA Act, Section 51E was amended to include your commute from and to workplace, also as in course of employment. And so if any employee was to suffer any injury during his commute, he's entitled to the benefits of the ESA Act. We'll just look at a few decisions on this where they've said that the notional theory can be extended. This is a case where the employee was residing close to the railway track, and then he found that there was some kind of activity going on in the railway track, and when he tried to stop it, in course of that, he was killed. And therefore, the question was, he was not during work hours, it was after work hours on his own volition. He had gone to protect the property of the employer, and the Supreme Court did held that his family will be entitled to receive compensation. The employee, as part of his work, went to fetch food for the employer from his residence, and as part of it, during that, he got injured, and fetching food was considered to be in course of his employment, one of his duties, and it was held that he was entitled for compensation. While traveling in an office car, this is a common phenomenon these days. The Supreme Court has said even there, the theory of notional extension applies and the compensation would be payable. This is at work site. The question was whether an act of God, a natural phenomenon like a lighting striking an employee will be entitled to compensation. Once again, Supreme Court said it is in course of employment. It was in the work site, and therefore the employee would be entitled to compensation, though there was no fault on the part of the employer, which led to the accident. And the next set of cases are where it has been held not to be extended. So an employee was already suffering from a heart disease, and he met with an heart ailment in course of his working hours. The question was whether he would be entitled to the benefits of the Employees Compensation Act. The Supreme Court said his operation or the nature of his work was only to operate a switch in a thermal power station, which was certainly not going to be stressful. And the reason why he died was owing to an ailment which he was already suffering, and held that he will not be entitled to any compensation. This is a case where the employee was residing in an accommodation provided by the employer, and the accommodation got burnt, and the Supreme Court concluded that there is no nexus in the employment and the residence or the fire, and consequently held that he will not be entitled to compensation. as I said already, this has got earlier, these are earlier judgments, but both the Employees Compensation as well as the ESA Act have now extended the theory to cover to and fro from work. So this is one more case, such case where the accident happened, but the courts found that it was not his normal or the closest route in which he usually takes. And therefore, they said that he will not be entitled to compensation. So even though to and fro has been covered, if he's gone somewhere else for some other, maybe let's assume that he goes for some function and then he goes home and there he gets hurt during the course of that travel, he will not be entitled. Similarly, there are a few more case laws. Given the paucity of time, I'll just skip through them. We shall share these citations with you through our PPT. In our Did You Know segment this month, we just found out that there is a data that's been collated recently and which shows that the EV industry is employing more women than men. We thought it was an interesting fact that should be shared with our audience. In the case law corner, we have two case laws. One is from the High Court of Madras. This is pertaining to a judgment rendered with regard to the Tamil Nadu Industrial Establishment Conferment of Permanent Status Act. This act provides that an employee, if he has worked for 480 days, he would be entitled to be granted the status of permanent employment. The question before the court was whether contract workmen can maintain an application and seek permanency with the principal employer. The High Court has held the Act does not cover contract labor and therefore contract laborers cannot seek permanency under the Conferment of Permanent Status Act. This is in a slightly different, of course, it's in a service law context, but it will have an implication even for private employers, where nursing assistants were being engaged. They made a claim for a payment called as nursing allowance, which was being paid to nurses, qualified nurses. The High Court held that the person, though termed as nursing assistant and did not possess nursing qualification, given the nature of employment, would be entitled to nursing allowance. But the Supreme Court dismissed the claim, and held in favor of the Border Security Force and said that different educational qualification and experience can be a ground to have different pay scales and different allowances, and rejected the claim for nursing allowance. In our Lex Posh, it's a case of where the proceedings under the Posh Act was being challenged on the ground that Section 11(4) of the Act states that the complaint should be completed within a time limit, and therefore as the complaint or the inquiry process had gone beyond the time limit of 90 days, the inquiry should be discontinued. But the High Court said that the time limit provided in the Act is more not mandatory, but it is more recommendatory, and observed that the inquiry can proceed and it is not some kind of a mandate that you need to complete it within the 90 days. Giving our answer out to the quiz question, it's all the above. The Occupational Safety Health is just not a substitute for the Factories Act, but it tries to subsume quite a few enactments, including the Mines Act, Plantation Labor Act, and the Working Journalist Act. So therefore, it is applicable to all the different industries that we have mentioned there. A short slide on the complaints to be carried out in the month of February. We would, of course, be sharing the PPT with all our participants. Thank you for joining, and our next connect would be on 25th February at 4 p.m. Please do join. Please do stay along for the IR Guru conversation of January 23. Mr. Ramesh, if you could take it over from here, it's all your show from here.